Welcome, everyone who's joining today. My name is Jeff Dagner. Many of you may know me. I'm one of the founder and managing partners of Ausperity Private Wealth, and I'm pleased to be joined today with Jerry Rothkopf. Jerry is the founder and managing attorney of Rothkopf Law Group. He's a nationally recognized leader of elder care, life care planning, asset protection, estate planning, veterans benefits, and long-term care advocacy. Jerry is a passionate advocate for seniors, individuals with disabilities. Jerry is a frequent educator, author, and speaker for legal and professional organizations throughout the country. He has authored a few books, The Unintentional Advocate, and co-authored A Life Care Plan. He has served as both president of the New Jersey chapter of the National Academy for Elder Care Attorneys and the Life Care Planning Law Firm Association. He's received numerous awards for his commitment to improving lives of older adults and their families, and continues to be a leading voice in aging, caregiving, and long-term care planning. Welcome, Jerry.
Thank you, Jeff. I appreciate the invite from you and Ausperity, and thanks from Jennifer from my office for helping facilitate this. So thank you, everyone. For those of you who are caring for an aging loved one, or maybe you have some issues yourself, or maybe you want to look at the future, and I invite questions and comments, and I don't know what the protocol is, but everyone probably knows how to use the Q&A. The goal is to have some dialogue back and forth and not hearing me pontificate for the next 30, 45 minutes or more. So feel free to do so. It always makes it more exciting. So I'm going to share my screen, tell you a little about what we do and what our office does. Let me just tell you a little about ourselves and how we operate. And if there's any, and feel free to comment all along. I'll be happy to stop and address any questions you have. So a little bit about ourselves and what we do, just for your own knowledge. We've been around for about 27 years. I'm the founder of the firm in early 2000. We currently serve South and Central New Jersey. We have 3 offices, with the South Jersey office based in Cherry Hill. We have offices from Trenton down to Turnersville. And then we have 5 offices in Eastern PA and all over Philly and its suburbs. So in essence, we work from Chester County and in the western suburbs of Philadelphia, really to the Jersey Shore and everywhere in between. We have a staff of about 50 people, which includes currently 8 attorneys. And we also have 8 full-time geriatric social workers. I'll explain a little about what they do, because they're an integral part of advocacy for older adults and those living with disabilities for our clients and their caregiver loved ones. We also have a health insurance advocate. We have 2 home modification specialists who are occupational therapists who help clients with home modifications who have difficulty navigating their home. We have 2 death doulas who address clients and spiritual and end-of-life needs. When we have a dementia coach, since we work with many individuals and their loved ones who have some form of dementia or related Alzheimer's disease. And ultimately, the goal is to advocate for those with chronic illness. And the types of cases we handle are, understand most of the clients who come to us or their loved ones have chronic healthcare issues. So we spend a great deal of time with crisis healthcare planning for our loved loved ones, addressing their immediate care. We also work with help them through the Veterans Administration and all the red tape involved to access benefits if they're a veteran or the widowed spouse of a veteran. And we also spend a great deal of time with our clients with Medicaid planning as well, and planning and applying for Medicaid benefits. The vast majority of our work is what we consider called life care planning. And that's really a combination of elder care advocacy, legal work, and healthcare advocacy through our geriatric social workers. And I'll give you some case studies to explain what I'm talking about. From pre-planning, we do elder care protection planning, meaning maybe if you're a healthy 65, 75-year-old, and maybe you have a shore property at LBI, down in Longport, wherever, and you're looking to protect that second home, and maybe one of the spouses was just diagnosed with a chronic health care issue that you're concerned about long-term care expenses. So we do elder care protection planning. We do general estate planning, wills, powers of attorney, but it's geared for individuals who have or may in the future have a chronic health care issue. We do special needs planning. So if you're a parent with a child who has autism, cerebral palsy, any form of disability, we deal with it and do special needs planning for that family. And naturally, since our clients tend to be older adults, we also would engage in estate administration when appropriate when a client passes away and help administer the estate. So in short, in a picturesque perspective, we have the client and their caregiver loved one in the middle, and we're navigating these different pieces of a puzzle. And that puzzle could include VA benefits. They may say, okay, well, how do I qualify for Medicaid? Can you help me through all the red tape with the Veterans Administration and accessing benefits? Mom needs home care. What's the best home care agency? How do we take the keys away from dad, who refuses to give the car keys away and refuses to stop driving, although we know it's a significant safety hazard because he's been in 5 accidents in the past month, but he refuses to give up the keys? What's the best assisted living community? How does my loved one get the best nursing home care possible? Those are the issues we all deal with. So I want to give you a quote, and if you can put in the comments or feel free to unmute yourself if appropriate. I would like you to tell me, this is a quote from a famous American, and I would like you to tell me who said this quote and in what capacity. I'll read it to you. No longer will Americans be denied the healing miracle of modern medicine. No longer will illness crush and destroy the savings that they have so carefully kept. There's a couple words cut off. So carefully. It's like stowed away over a lifetime so they might enjoy dignity in later years. No longer will young families see their own incomes and their own hopes eaten away simply because they are carrying out their deep moral obligations to their parents, their uncles, their aunts, etc. And no longer will this nation, meaning the United States, refuse the hand of justice to those who have given a lifetime of service and wisdom and labor to the progress of this progressive country. So
I got to believe it was a president who enacted, maybe Medicare or Social Security.
You are correct. That's excellent guess so far. But who was that person?
Seems like our audience is also stumped.
Stumped. All right. It is President Johnson, 1965. This was his prepared speech. As Jeff indicated, he was correct when he signed the Medicare and Medicaid bill into law. 1965 was when Medicare became law in this country. Same with the Medicaid bill. So he was referring to Medicare, basically universal health care insurance for individuals who are 65 or older or blind or disabled prior to age 65. This is a rhetorical question right now. We're still trying to figure it out. Does this ring true today to you? It's a rhetorical question. Feel free to answer it. I think you know what my answer is going to be. No is the answer.
Yeah.
There's a lot of reasons why that's the case. One of the reasons is a very practical reason. Medicare was never designed to cover long-term care costs. Of course, 60 years ago, it was people were not living as long, and the long-term care business was much different. It was mainly nonprofit. Now today, it's mainly for-profit. So it's big business, in other words. You didn't have these assisted living communities that existed 60 years ago. You didn't have these mega nonprofits owning nursing homes and other long-term care communities. It was mostly a very church, synagogue-oriented type of care, but that no longer applies today. So there's lots of reasons why. The fact of the matter is we see many of our clients, even those who have relatively significant assets, spent for long-term care expenses. Some of the common issues that financial estate planning professionals and those clients of estate planning professionals want to review some of the common issues that we deal with, okay? And then I'm going to do some case studies, and feel free, again, if you want to stop me, if you have any questions, or if Jeff, you have any questions, or your team, by all means, please ask, okay? First of all, one of the issues, and Jeff and I were talking about this before this session, was, do you recommend long-term care insurance? Generally, the answer is, and I think Jeff will agree with you, yes, we do in the right circumstances. The question is whether it's the right circumstances. Most of the clients who come to us are not insurable. Why aren't they insurable? Because they have chronic health care issues. Most tend to be 75 plus, so they may not qualify because they already have some chronic health care issues, or they may qualify, but it's prohibitively expensive at that point in time. So, but the best time to purchase long-term care insurance is probably typically, Jeff, feel free to comment, probably by your mid-50s.
I agree. And
Okay.
like you mentioned, long-term care facilities becoming for-profit, insurance companies are also very much for-profit. So they can pick and choose who to insure and who not to insure.
I mean, I have people purchasing long-term care insurance in their mid-40s. I think that's a little young, but maybe they have maybe there's reasons for it, such as maybe their parent was diagnosed with Alzheimer's at a young age in their 50s. So they want to insure against that potential risk because it could be genetic. So there's some reasons why you might want to purchase it younger, or you just have some funds. Sometimes it's insurance. I'm sure Jeff can counsel you accordingly and his team, but most long-term care insurance today it's not sold the way it was 20, 30, 40 years ago through a standalone policy. It's more of a use it or lose it policy. Now, most of the policies are sold kind of a hybrid in conjunction with some form of life insurance policies or annuities. It's not in other words, it's not a use it or lose it proposition, but it can be pricey because now it's life insurance and it's permanent life insurance. So, which is obviously much, much more expensive than term insurance. So it is recommended in the right circumstances, but it has to be affordable. As Jeff said, you need to be insurable. And you have to have assets to protect. So what I will, and I always get the question, well, my mom's 92 years old. Is it too late to plan to preserve assets? No. The only time it's really too late to plan is when you're dead. So it doesn't even if you have a loved one already in a nursing home, it's not necessarily too late to plan. So there are certain rules, such as what's called a Medicaid 5-year look back, but there's many exceptions to the 5-year look back, and I'm going to touch upon a few of those this afternoon. And for many of our clients, when we talk about most of our clients who have significant funds, for the most part, they're in what's called qualified funds, meaning tax deferred IRAs, 401ks, 403bs. That's the vast majority of their savings typically for retirees. So and tax advantage funds. The problem with that when we look to move them around is it's generally considered taxable income. So when you talk about preserving assets, you always have to take into account tax issues, meaning if you have a $1.5 million IRA and you want to transfer that to your spouse or your kids or even a trust, guess what? If you liquidate that in 1 year, generally, you're going to have a $1.5 million tax bill. I'm sorry, $1.5 million in additional income that in New Jersey puts you in the 40% plus tax bracket, with state income tax as well thrown in. So that's a big tax bill. Most of our clients would not be happy campers if that happened. So you have to be cognizant of what type of assets what's the makeup of your assets, decide what to do. For those who have loved ones or live in Pennsylvania, we work, as I said before, in PA and New Jersey. Each state law is different. Pennsylvania is different than New Jersey. For example, if you have a loved one who with spouse, and you have a healthy spouse with a large retirement account, guess what? In Pennsylvania, if your spouse needs nursing home care, that healthy spouse's retirement accounts are totally exempt from countable assets for Medicaid eligibility. If you live in New Jersey, they are not. So sometimes it's a matter of what state's laws make sense, especially if you live right on the border between states. Also, in Pennsylvania, generally there's no Medicaid coverage for assisted living. There is, even though on a limited basis in New Jersey. So yeah, each state has different laws to a certain extent. Do you have a child living with a disability? Well, as I talked about, we do special needs planning. So maybe if you have a child with autism, cerebral palsy, Down syndrome, sometimes it's even mental health issues. There may be a special needs trust to hold assets for a disabled individual may be appropriate as well. People come to us who have made gifts within, as I mentioned before, the 5-year look back, and they're concerned about those gifts affecting the parent's eligibility for Medicaid. So, it may, but there's ways around it. So we spend a great deal of time with our clients navigating those issues. And funding long-term care, I would say, is a middle-class issue. For some clients, they can self-insure. So sometimes the children who are in their mid-50s to mid-60s may maybe doing very well and have significant savings, but maybe mom and dad don't. That's typically what happens. Maybe mom and dad, maybe they, as I said, they have a shore property and they purchased the shore property 60 years ago for 50 grand. And now they have a property in LBI worth $2 million. Pretty damn good investment, but they want to protect that shore property, which is by far is their largest asset.
Which I would consider as an illiquid asset, The property becomes a big part of asset protection because you don't want to be forced to sell a home or a property, especially if it's been in the family.
Right, and sometimes that shore property becomes, quote unquote, the family compound, where they want to keep it from generation to generation. Besides potentially a big, if they sell it, you get a big capital gains tax bill. So in those cases, maybe it makes sense to transfer that property to a trust, incurring the 5-year look back, but you can maintain the stepped up basis, so it would go to the next generation tax free without capital gains. So there's reasons why you might want to take that property out, especially a second home, property in the lake house in the Poconos, similar, something along those lines. Sure.
There's a lot of this life care planning, as you can see, because many people consider estate planning and not so much the progression of estate planning, but it's all interrelated. A lot of the work that we do is very much connected to the extensions of our team that we engage with, Jerry being one of them in his firm. So estate planning, asset protection, and basically life care planning are all very interrelated.
Right, and you as clients, you may be relatively well-to-do, or maybe you can self-insure, but maybe your parents can't. You may be a business owner, 55 to 65 years old, but you may have a parent, 85 to 90, who is not as well-to-do, or maybe they worked hard all their lives, but they have minimal savings, and most of their equity is in their home. Those are the typical clients we work with. So that's why I'm saying long-term care is a middle-class issue. And because if you have no money, well, there's not much to protect, granted. And if you're relatively well-to-do, maybe you can self-insure. But for the middle class, that's the issue, where qualifying for government benefits can be quite important to protect a healthy spouse or a child with a disability. There's this 5-year look back. Most people do not understand how it works. One thing to understand, there are many exceptions to the 5-year look back. And one of the focuses we spend a great deal of time with our clients is figuring out what type of assets are exempt and what's not. For example, you can purchase, you may not heard of this concept, it's called a SPIA. Typically we do that when there's one spouse healthy, one spouse not so healthy, and they're concerned about protecting the healthy spouse. So you can purchase what's called a single premium immediate annuity with spousal funds for the benefit of the healthy spouse to turn countable assets into an income stream for a healthy spouse. That is legitimate planning under federal and state law for Medicaid. You can protect the resources of the spouses by purchase of that SPIA and turn it into a stream of income.
Does that work for Pennsylvania and New Jersey?
Yes, it's based upon federal law. So it's similar laws in both states.
Yes.
Okay. So, the question always is among elder law attorneys, when does the pig principle apply? What do I mean by that? Would I do, in theory, you can do it for unlimited amounts. Would I do it for someone with $5 million in total assets, and where we're going to tie up money for maybe a 5-year period, and the healthy spouse is going to get 100,000, 250,000 a month for 5 years or something like that in monthly payments? No, I probably will not. That's the pig principle, if you understand what I'm saying. Will I do it with someone with $500,000? In a New York minute, I would. You understand what I'm saying? So at some point, although it's on paper, it's legal, from a pragmatic perspective, you might want to avoid it. But I certainly would do it with much smaller sums. So you can transfer assets between spouses, real estate, assets. It's when you transfer funds to a child who's not disabled or any third party that's an issue. You can transfer to a disabled child or a special needs trust. That's SNT, special needs trust, for a child with a disability. You can transfer a home to what's called a caregiver child, which I'll explain, I think, in one of the case studies that we'll do.
why would you want to transfer assets out of your name, more or less, for Medicaid purposes?
To protect them. That's the reason. The same like the example of the sewer property, to protect them so it's not subject to countable assets for Medicaid. And if you have a loved one on Medicaid, it's not subject to a lien that may attach if they own a primary residence. So it's really from an asset protection perspective is the reason why you may do so.
Okay.
That's really it. Then there's what's called the 5-year look back, but there's some exceptions to 5-year look back. One of the exceptions to the 5-year look back are gifts made for purposes other than Medicaid eligibility. What do I mean by that? This is a tough one to get through, but the best way to explain that to you is you're healthy one day, you're not healthy the next day. Meaning that, let's take an example of someone who has a massive stroke. On July 23rd, they're healthy, they're working, and they're driving. Maybe they don't run a marathon. They're in their mid 70s, still working or volunteering. Maybe they're not running marathons anymore, but they're still totally independent. Unfortunately, later on today, that same individual has a massive stroke. Now they need 24/7 care. There are 2-person assist to get out of bed. That's what I mean by healthy one day, not healthy the next day. So you didn't plan on having a stroke, obviously, and maybe now you need 24/7 care, and nursing home care could be $18,000 a month privately, $600 a day, let's say. And now there's a spouse needs protection, and they're middle-class individuals, and you were kind enough, maybe you helped a child afford a down payment. You gave that child 50 grand 2 years ago for down payment for a house. You helped the children pay for private school or college for that grandchild. So you gave away a couple $100,000 within the past couple years, within the 5-year look back. Your intent was not to hide money for Medicaid. Your intent was to help family members. That's what I mean by transfer for purposes other than Medicaid eligibility. You need the right facts is what I'm trying to say. So that's just an example of having the right facts, okay? So most of what we do is no one comes to us generally because they need a will. You go elsewhere if that's the case. They need a will because their loved one just had a massive stroke. They need a will because they have a special needs child. They need a will because they were recently diagnosed with some type of chronic illness. That's why people come to us. So, but if you need just a simple will, we're probably not the firm for you, okay? So let me give you a couple case studies, then I can open it up for further discussion as needed. So these are actual clients that we worked with over the past few years. So we have an 80-year-old father living with his son in South Jersey, and the daughter-in-law since April of 2026. The father was diagnosed with Lewy body dementia about a year ago, which is, for Lewy body dementia, people have hallucinations. It's a pretty insidious type of dementia. The father previously was residing in his own home, which he still owns. He is a retired police chief of a township in South Jersey. He is also a veteran of the Vietnam War era. Didn't serve boots on the ground, but was a veteran during the time, but active duty during the time of the Vietnam War, say between 1965 to 75. The family is attempting care for dad in child's home, but realize it is too much. The goal is to move dad to a local assisted living community near them in South Jersey, specifically Gloucester County. The family's concerned is how to get the best care for the dad. His assets are, again, very middle-class individual, I would say. He has a $175,000 home plus $200,000 in savings. He also has a total income of $5,000, which is his state pension as a police chief, combined with Social Security. So this is what we would consider a life care planning case, in which we would have our attorneys and geriatric social workers working together to coordinate care for the loved one. We want to update wills, powers of attorney. In this case, we maybe consider funding a trust here. We would fund the trust possibly with the dad's home, subject to the 5-year look back potentially. And We would also assist with memory care placement, which would be about $12,000 a month in the South Jersey area for assisted living memory care, a high level of assisted living. We would also want to apply for this gentleman for veterans benefits. And that's why another reason why we would put the home in the trust and then sell it in the trust. There's an eligibility limit of asset eligibility limit of $162,000. So by putting the home in the trust, it keeps the assets, he's under 162K after he spends down $200,000 in savings to below 162K. If we can get him eligible for VA, and we can here, he can receive another over $2,500 in monthly tax-free income through the Veterans Administration. Well, he already has $5,000 in fixed income, so now he's up to $7,500 in fixed income. So that his net expense might be $5K a month. So with his $200,000 in savings, plus any proceeds from the sale of the home, if his net expense is $5,000 a month, he probably has enough to live in an assisted living setting the rest of his life. I mean, certainly, 5+ years at $60,000 per month. So that's just an example of, in this case, I probably would use VA planning as opposed to Medicaid, because that would probably be enough for this gentleman, this retired police chief. So another one, a little different. This is more special needs plan. We have an 85-year-old widowed mom who lives with her 55-year-old child with cerebral palsy. So we have an elderly mom with a special needs child, in other words, who's living together for all their lives. The mom unfortunately needs nursing home care, but the family is concerned about where the 55-year-old adult special needs child will live. Mom owns the 375K home in her name. She has $650,000 in other assets. The special needs daughter is receiving supplemental Social Security and Medicaid benefits. What does that mean? That means she has assets of under $2,000, so we can't give her any money outright, or it would disqualify her from receiving those valuable public benefits. Lose income, lose health insurance, etc. So the family's goal here was to get the best care for mom while preserving assets for the special needs daughter. So this would be long-term care planning and special needs planning. So number one, unfortunately, mom needs 24/7 nursing home care, so we'll review nursing home options for her. Then we also need review options for the daughter. If the daughter can't stay home anymore, where's she going to go? The group home generally has a wait list, so we have to navigate the disability resources in New Jersey for this individual. And then decide the plan for the daughter. We would draft a special needs trust. I talked about that earlier. In which the assets can then be deposited into a special needs trust to the benefit of the daughter. The transfer to the special needs trust to the daughter is not counted as part of the Medicaid 5-year look back, because there is an exception to a transfer to a trust for the benefit of the special needs daughter. And the money in the special needs trust would not count for the daughter's $2,000 limit. So in short, we can get the mom in a good nursing facility. She can qualify for Medicaid, and we can set aside funds to be used for the 55-year-old daughter's rest of her lives within a trust to be administered by one of her siblings as trustee. So that's how that worked. Okay, so it's kind of a combination of planning there.
This certainly resonates. I've engaged with clients that have multiple children, one of which is special needs. And opposed to, they're well aware of the aspect that they can't leave assets to the special needs child outright, which would exclude or preclude them from state benefits or federal benefits, but they leave everything to the other child, assuming that child is going to then take care of their sibling. Yeah. And I feel that that's kind of passing that child off to somebody else, and there's tax ramifications in many cases of that individual then, relying upon the assets, especially if they're retirement assets or qualified assets, to, care for that child.
Yeah, I generally agree with you, Jeff. I generally try to talk the family out of it, because typically, I'm just going to exclude my daughter. I'm going to leave everything to my son. And I'm going to have my son take care of his special needs sister. Yep. And that's what we sometimes hear, and we kind of try to talk them out of it, because it's a big burden, and they probably have their own family and their own kids to take care of, and so that's a burden. So we try to have a third party named as a trustee, sometimes a professional trustee, or there's different nonprofits who can serve as a trustee. And of course, if If you leave it all to one child, you don't really know what skeletons in the closet that child has, do you?
Yeah.
So it may be subject to, there's not a guarantee those assets can be protected. It could be subject to creditors. It could be subject to equitable distribution if it's a divorce situation for that child. So it's always sometimes best not to do that. So it's a good point, Jeff. So the third case study, now you have a couple with more assets here. They've been married 50 years. The husband was diagnosed with Alzheimer's disease 3 years ago and has progressed to such an extent he needs 24/7 care at this point. The wife is independent. She still drives, but she never really handled financials because that was just how it was back from when they first got married 50 plus years ago. She's unaware of the financials and how her husband handled the finances. They have a house worth in equity with no mortgage of $650,000, and they have about $1.5 million in other funds, plus a small long-term care insurance policy that pays $100 per day. The goal is for husband and wife to remain together, but they cannot do so in the current home. It's a two-story colonial, and the bedrooms are on the top floor. It's just not conducive for them remaining at home right now. So from the planning then is, get care at home with a shorter term or shorter time limit. And then over the longer time limit, we want to make sure they have wills, powers of attorney, advance directives in place. And then we want to review housing options. Now, given they have over $2 million, if you want to count the equity in their home, they have some options here. One option that I particularly like when we have spouses who have different levels of care, since the wife is still independent, I would look at a continuing care retirement community arrangement for them, otherwise known as a CCRC. In South Jersey, you may have heard of the Evergreens in Morristown. You have Wiley in Marlton. You have Medford Lees in Medford, places like that offer what I would refer to as Lions Gate in Voorhees, that offer a continuum of care, meaning they have independent living, assisted living, and nursing home under one roof, so to speak. That is a retirement community. So, and then the nice part about this is that although spouse and spouse may not be in the same unit, they typically would be under one roof, and they can have as many meals together as possible. The husband could be in assisted or nursing, and the wife is in independent living. It's not for everyone. Not everyone is thrilled to go there. Don't get me wrong. Some people, it's community living. There's a main dining room, but for the right people, it makes perfect sense. And for couples who have different levels of care, it makes sense. But you also have to understand the financial commitment, which is important. It's a six-figure entrance fee you typically have to pay. And depending upon the square footage and the type and how luxurious of the community you're going to, it could be anywhere between $150,000 to $650,000 entrance fee. Some of those contracts are refundable. Some of the contracts are non-refundable. And then there's kind of a hybrid of those two where it can depreciate 2% per month for 50 months. So our focus is to determine if it's appropriate, and if so, what type of contract you should enter into. So we'll review the contracts that found.
And I've also run into this with clients, those that are refundable are much less deductible at the onset. Those that are non-refundable, tend to be more tax advantageous. So that's what I mean early on when there's a number of different professionals involved in the equation with some of these decisions.
Yeah. I wasn't going to too granular with that, but you're absolutely correct, Jeff. It's really important to determine what type of contract to enter into from a tax perspective. The other issue that is the refundability. If you choose a refundable contract, which sounds good, typically you'll have contracts that are 90% refundable and payable to your estate if you die or leave the community. The problem with that is what triggers the refundability. Typically, it's refundable only in certain circumstances. When you vacate the unit and another individual takes over your unit and pays another entrance fee. However, that could be 2-3 years later after you die. So your estate would have to wait to get that significant lump sum. So, and it's a loss of use of that money, obviously. And as I'm sure you can imagine, that money is not gaining interest. That's like a bank, when you give money to to a certain extent, well, it is not like a bank, because in a bank, at least you're getting interest. The way they make money, these CCRCs, they invest your money. So they're investing that $500,000 that you give them for the life of you're there, for living there. It's held in escrow. You can't access it. So when you don't get that back right away, that's something also to consider. You want to review the community's track record. What's their policy about refundable fees, and how long will that take? That's an important question to ask. So those are the three kind of case studies. So that with the typical cases we deal with on a regular basis. And our goal is to get the best care for family members. Yes.
Do you and your firm help clients review the contracts with the CRCs?
Yes. We spend a great deal of time. We spend a great deal of time with families, helping them negotiate the what contract to choose, and then what type, and reviewing you get like 100+ pages with all these financial disclosures that's required by state law. We determine what's the financial viability of this community. We help them determine what type of contracts, where to sign, maybe more importantly, where not to sign. That's all part of the services we provide. Yes. Ultimately, our goal is to put those pieces of the puzzle together. That's really what we do. So, and we are a resource for financial professionals, for caregivers, for anyone involved in caring for an aging loved one. So with that, I will be happy to open up the floor. If you have any questions, thoughts, anything that I didn't mention that you want me to answer, feel free to fire away.
Yeah, I'm keeping an eye on the chat. I don't really see much questions that have come through, and in a lot of cases, this is a lot to take in and digest. So if anything does come back after the fact, we will connect with you and try to get those answered.
So yeah, there's our website. Feel free to go on it. If you can send me an email through the website or we have a lot of resources on the website that I will refer you to. Our senior guides, our VA guides. So there's a lot of information on the website that's free, by the way, that you can download and use if you're in we have senior guides for in Pennsylvania. We have a senior guide for New Jersey. It has all long-term care communities, home care agencies, also different types of support groups for loved ones on there that you can access.
No, this has been great. I mean, the one thing I can share, many of our clients hear from us, the need to basically an estate plan is the ability to manage your money from the grave, and the more predictability that you create, the less stress and impact it's going to have on your children down the road. My connection with Jerry and Jennifer, which you mentioned earlier, was one where Jerry and his firm takes it in a completely different angle and really focuses on that life care element, which I think is it really hits home to anybody that has dealt with it, especially with a loved one, or maybe it's an in-law watching a spouse go through it, because you can be one of, you may have several siblings, but the care for a parent usually falls to one. And sometimes it falls to the many financially if not planned appropriately. We share with clients, a number of different financial stress situations that can really impact or derail their financial plan. And one of the greatest threats to their financial wellness is not market volatility, but it's an unplanned long-term care event. Estate planning and life care planning can really help create the legal framework that protects assets, preserves family wealth, and provides options for quality of care when it's needed most. Estate planning is one of those concepts, and I think it's important to ensure that your estate plan is consistent with your life care plan. I guess really just to follow it up, I mean, the most effective planning really occurs when financial advisors are equally engaged with the elder law attorneys and the life care planning professionals, and they're all working together for the benefit of the client.
Agreed.
Jerry, thank you for joining us.
All right. Well, thank you. I thank everyone for their time and interest, and I thank you for the invitation and hospitality.
Absolutely.
Have a great day, everyone. Thank you.
Thank you.